Gov, and here today to talk about the October visa bulletin. We have, of course, Charlie Oppenheim with us today, our visa expert. Charlie is the chief of the Immigrant Visa Control and Reporting Division, which administers the annual numerical limitations on immigrants subdivided by preference, category, and country. Before we get started, just a reminder that the event is live streaming and it will be recorded and posted to our YouTube channel. And this event is intended to address issues of general interest related to the content of the October visa bulletin. And unfortunately, we cannot take policy, case, or post-specific questions at this time. Please, if you have a question for Charlie, please post it in the comment section of the live event, and we will try to get to as many as we can, the more frequently asked questions during this live event. Okay, so now we're going to get to first our previously submitted questions. We had questions submitted ahead of time. So let's get right into it. Charlie, first question. Last month, when describing the National Visa Center's processing of cases, you mentioned a change in terminology from documentarily qualified to documentarily complete. Why the change and what's the difference?
Well, the terminology means exactly the same. It's my understanding that by changing it to complete, the National Visa Center was just trying to make it very clear to the applicant that they had submitted all of the required documents, that all those documents have been reviewed by the National Visa Center, and the case is considered to be complete and ready for the potential processing in overseas post when an interview can be scheduled.
Gotcha. Just a terminology change.
Yep.
All right. Next question. In the September visa bulletin, the application dates for filing, which are listed for China and India EB3, were July 1st, 2019 and March 1st, 2014, respectively. But in the October visa bulletin, the dates for filing for China and India EB3 were moved back to January 15th, 2019 and January 8th, 2014, respectively. Why did you move these two application dates backwards?
Each month before I'm making the determination of the final action dates and the application dates, I consult with the USCIS officials, and their inventory projections show that on October 1st of 2021, coming up, the pending demand, which both state and USCIS has in the employment third preference for applicants born in India and China, will already exceed the amount of numbers that are available to applicants from those countries throughout fiscal 2022 in the third preference category. And therefore, for that reason, we made the decision to retrogress those application dates for filing, to limit new applications, which we did not at the time anticipate could be processed during fiscal 2022. But it is important to remember that, as with the final action dates, we always continue to monitor the situation very carefully, and that allows us to determine what, if any, future action will be required.
Okay. Next question. In the projections of visa availability in the coming months, you mentioned that some of the retrogression of the employment final action dates could occur as early as November. Would such retrogressions be in months or years?
At this time, I can't really estimate how much the employment retrogressions may be or how soon they will occur. I just wanted to alert all the viewers and readers of the Visa Bulletin that the retrogression was a potential action. At the beginning of October, I will make a review of the amount of demand that we have in-house and immigration service demand, which is expected to reach us in the near future. So again, I will monitor USCIS use of the numbers to determine when it's going to actually be necessary for the retrogression. And should a retrogression be required, the goal is always to have them be a one-time retrogression to minimize future use, but still have the potential for forward movement at a certain point later in the year if the current level of demand were to subside and allow such movement. Another consideration is that there could be legislative action which may impact the fiscal 2022 annual limits, and such potential action would be considered before any corrective action would be taken. The reason is that we would not want to retrogress any of the dates only to then have to, advance them a short time later. But it is worth mentioning that the longer I wait to have any corrective action, that delay would eventually, if it's eventually required, the retrogression would be more dramatic. So again, a delay in doing so may cause the ultimate retrogression to be a little bit more than it might have been if it had occurred earlier on.
Right. All right. Thanks. Next question is, why did you indicate that retrogressions may be required for certain employment final action dates?
Well, under the current Immigration and Nationality Act guidelines for determining the annual limits, I still believe that the fiscal 2022 employment limit will be approximately 290,000. But it is important to note that even under that sizable limit, which would be the highest ever, there are already more than enough applicants who have filed in the employment third preference category to use all of the available numbers under that limit. And this is the same reason I just mentioned in terms of having to retrogress the employment third preference application filing dates. So again, this action has been taken after a very careful review of current and likely demand in the near future.
All right. In response to a question asked during the discussion of the September visa bulletin, you said that you did not expect any retrogression of India EB2 and EB3 preference categories. Why have you changed your projection?
Well, when I make the determination of the monthly final action dates and respond to questions during this event, I do so, based on the best information and most comprehensive information available at the time. And that's what resulted in my comments back when we did this show in August. In recent weeks, my discussions with the USCIS regarding the amount of worldwide employment third preference cases, which are expected to be finalized by their officers in the next few months, combined with the subsequent final action on cases which are filed have been filed in recent months based on forward movement of the dates. This required a reevaluation of the situation with the India employment third preference category. And also, as more rest of world applicants in the EB3 category are finalized, this would automatically mean fewer, quote, otherwise unused numbers, which would be available for potential use by the Indian applicants. That otherwise unused number use is what has allowed the India, both the second and the third preference dates, to advance so quickly throughout fiscal 2021. Another consideration I have to do is the fact that my overseas posts have the potential to dramatically increase their use of numbers in the coming months as they begin to return to normal processing. And those offices are going to be catching up on cases that may not have been addressed, in the past year or so because of the pandemic consideration. And this is really a perfect example of how the visa availability situation must be constantly monitored and adjustments made, throughout the year.
Yes, definitely. What happens with the case of an applicant who had originally filed and has a case pending in the employment second preference category, but they subsequently attempt to downgrade their case to employment third preference because of more advantageous filing action date? final action date.
Right. Yeah. Well, if the case action was originally initiated with USCIS at the time when the employment second preference number was available, but the final action date retrogressed before the applicant's case could be adjusted, then the Immigration Service would go ahead and request an employment second preference visa authorization. Then that case would be held in our pending demand file until subsequent forward movement of the EB2 date allowed us to authorize the visa authorization for that applicant. If the applicant were to downgrade to EB3 status and that was approved prior to the time the second preference number became available, then the USCIS processing office would withdraw their original EB2 request and submit a new one in which would be immediately authorized in the employment third preference category. So again, they could, and this could be the same thing, somebody could upgrade their case as well. So somebody could have filed originally in the third preference category, but in the intervening time, they've become eligible for employment second preference status. They could also upgrade. And this is an event we see typically with both the India and the China employment applicants, and it's a pretty standard practice.
Okay, thanks. Next question. I was one of the lucky ones to get selected for the program and duly submitted the required for the DV program and duly submitted the required documents for KCC processing. However, I have yet to receive any communication from KCC regarding scheduling an interview, and the deadline is fast approaching. When will I be notified?
Yes, this is one of the many questions. We got a lot of these questions on the advanced submissions, and the Kentucky Consular Center is scheduling cases based on the processing capacity to act on such cases at various posts. I cannot really comment on when or if certain cases may be scheduled. It may not be the case with this person's specific situation, but this is an example of why it is very important for applicants to always act in either their diversity visa or regular immigrant visa category in a very timely manner and not wait until there's an indication that either their rank number or their priority date is about to be reached. Because the cases are processed in basically a first in, first out case. So somebody that became qualified earlier in the year would be and was not able to be scheduled would be typically scheduled first. So it is important to do so. And with the diversity immigrant visa cases, again, they are being scheduled to the maximum capacity at post, but post capacity situations vary from country to country.
Right. All right. In the visa availability projections, you indicate that no movement of the family-sponsored final action dates is expected in the coming months. Why not?
Well, and I think I've mentioned this in past events. The family-sponsored and employment final action dates were advanced at a pretty regular pace since March 2020, when the COVID-19 issues first became an impact on our processing. The reason we moved the dates was to generate sufficient demand to maximize number use once the processing became possible at our post. And as we enter fiscal 2020, those movements have already generated enough demand to potentially use all available numbers, at least in the early months in the family issuance targets. Excuse me, based on the current immigration and nationality guidelines. And what we do on a monthly basis when determining the final action dates is determine how many numbers under the annual limit we would like to be used for that particular month, and then advance the final action dates accordingly to allow that target to be reached. But again, we already have enough demand based on the established dates to fully utilize all of the numbers for the foreseeable future.
Great. All right, this is the last previously submitted question. I am an Indian applicant who has been in the US for the last 10 years on a legal visa and in line for a green card for the last 6 years based on my approved I-140. Why do Indian applicants such as me have to wait so long while employment-based applicants from most other countries are being processed under a current preference status?
It's very important to remember that the Immigration and Nationality Act guidelines apply a 7% per country limit for which visa and issuances to any single country may not exceed. The applicants compete for numbers on a worldwide basis, and this 7% per country limit is intended to prevent a handful of countries from potentially monopolizing virtually all of the annual limitation in certain preferences, by those countries. Earlier, I mentioned that the India category, employment third preference category, has been benefiting by the use of, quote, otherwise unused numbers. That has also allowed China and India employment first preference applicants to benefit and be processed on a current basis. And the amount of Indian and Chinese applicants, therefore, far exceeds the per country limits. So they are benefiting greatly, but this was Congress's intent by the allowing the fall across numbers if the numbers were going to be otherwise unused, so that we could maximize number use. But right now, both, I can tell you, the India first, second, and third preference categories have far exceeded what the normal per country annual limit would be. So those applicants are deriving a great benefit, and because there would be otherwise unused numbers under the respective employment first, second, and third preference annual limits.
All right, thank you, Charlie. So now we're going to get into some of the live questions that we've been seeing on the comment section of this event. Just a reminder, if you're posting your comments, to just post one time. If you post a lot of times over and over and over, it actually makes it much more difficult for us to get to as many questions as we possibly can. So I'll post one time, please, and we will try our best to get to as many as we can. All right, first question, those who are documentarily qualified, isn't there something called expedite on the F4 worldwide category? And if so, what are the options?
No, there is no expedite. There may be an expedite of a case because the applicant is about to age out or there are extenuating circumstances, but only if the applicant's priority date is within the applicable final action date. Otherwise, no action can be taken. So somebody can't say, well, I have this special issue which requires you to process my case. That does not happen. There is basically the final action dates are effectively a line in the sand, which only applicants with a priority date earlier than that date can be processed. And the reason in part being that virtually anybody could come up with a reason why their specific case should be expedited. And it wouldn't be fair for my case to be expedited ahead of the other person's because I came up with a better story or whatever. So again, everybody is treated equally by the use of the final action dates.
All right. Next question. What about Haitian petitions documentarily qualified this year?
I'm assuming the question is in relation to the earthquake and other issues. It depends on post-processing capacity. I could not comment on that. The situation in the embassy is having to deal with numerous issues and doing their best in all areas of both American citizen services coverage, processing immigrant visas and non-immigrant visas. But the best thing I could advise is consult on the travel.state.gov website for the embassy in Haiti at Port-au-Prince and see what they may have posted in terms of what their processing ability is at this time.
Yes, definitely consult the U.S. Embassy Haiti website. That will be the most up-to-date information on what services we are able to provide at that location. All right. Next question is, will China EB3 advance this fiscal year?
The E3, as I mentioned in the visa availability comments, in fact, I'll read it directly to somebody. A retrogression of the China employment third preference date could occur as early as November. Again, if and when a retrogression is required, it is hoped that retrogression would be a one-time retrogression, and that potentially, if and when demand were to subside and allow it to do so, we would then advance the China employment third preference final action date. But at this time, I would not assume that would be possible for the foreseeable future if a retrogression occurred.
Right. All right. Next question is, when can we expect a normal interview process as before the pandemic?
That if you're talking about overseas processing, again, check the embassy website or consulate website of the post processing your case for the most recent information. We still have to deal with host country guidelines in terms of what can be done in terms of interviews, in terms of people coming into the embassy or consulate and et cetera. So again, would be a post by post process. In terms of processing it here in the States by USCIS office, again, you should contact their website for any information regarding what their processing is at this time.
Right, and we do have detailed information on travel.state.gov as well about our tiered system. We have 4 different tiers of prioritization for immigrant visas. So you can go to travel.state.gov and you can find the information about that. All right, next question. What happened to the 150,000 spillover number? Will it be added to the November bulletin?
Well, the 150,000 expected fall across of unused family-sponsored numbers, that is added to the normal 140,000 employment limit, which is a minimum, and that is resulting in the 290,000 employment limit, which I mentioned earlier. So nothing happened to them. They are being taken into consideration in terms of everything that will be done based on the current Immigration and Nationality Act guidelines when we're making the determination of the fiscal 2022 dates. But again, based on prior movement of the employment final action dates, we already have sufficient numbers to use all available visa numbers for the foreseeable future.
All right, next, just a reminder to people posting in the comments right now, we cannot comment on USCIS processing times. We are the Department of State, and USCIS is a completely different department within the US government. So we cannot comment on the situation happening in USCIS during this live event. Next question is, you kind of already have talked about this a lot, but we're seeing it a lot in the comments. What is causing the retrogression for EB3?
Again, the amount of, and I will give a specific example, the amount of Indian third preference applicants, because I was seeing this question in relation to India third a lot in the advanced questions coming into the visa bulletin email. The amount of Indian applicants who filed last October and November is almost enough to use the entire worldwide employment third preference annual limit. Therefore, and because of the 7% per country limits I mentioned, India will be limited to the amount of numbers they can use, and that is likely to require the retrogression. It's very important to remember that during October and November of last year, the amount of applicants which were filing was so sizable that it did require the retrogression of the India third preference application filing date from January 1st of 2015 back to January 1st of 2014. And that was done based on the unexpectedly high amount of filings in a very, very short period of time. So again, and the rest of world applicants, there was sizable filings of those applicants as well. And processing of such cases has been steadily progressing primarily through the second half of the year and greatly expanded during the summer months, where the Immigration Service is now processing over anywhere from 7,000 to 8,000 cases a month, which is an extraordinarily high amount, and shows the efforts they are putting forth in order to maximize number use to the best of their ability. But even so, we have such a sizable pool of third preference applicants that are ready to go at some point during fiscal 2022.
Great. All right. What about the November Visa Bulletin F3 visa category movement?
On the worldwide family dates, nobody should expect any type of movement before January. I do not, at this time, based on the information available, I do not expect any movement of the family-sponsored worldwide dates for 3 to 6 months and potentially longer than 6 months.
All right.
Again, we have such sufficient demand that based on the already established dates to fully utilize all available numbers.
Right. All right. Hi, Charlie. What are your projections for DV 2022 numbers advancement? Can we expect case numbers to proceed more quickly this year, given low number use in fiscal year 21?
The dates, the rank cutoffs for the DV 2022 applicants, those will continue to advance at a regular pace, probably at a pace consistent with the movement of fiscal 2021. They may be accelerated somewhat if posts indicate that they have processing capacity. I can state, though, that as I mentioned earlier in relation to a DV 2021 question of asking when they might be scheduled, the amount of DV 2022 applicants who are acting on their case in a timely manner by submitting the required documentation is extremely low. So again, applicants, if they are interested in pursuing action on any, whether it's a diversity, family, or employment case, they need to submit the required documentation in a very timely manner, because it does take time to process that information. And once it's processed and it is deemed that the applicant is documentarily complete, then that information is reported on a monthly basis to my office for consideration in the determination of the upcoming months, either diversity visa rank cutoffs or the immigrant visa final action dates. So again, I cannot stress enough the amount, how important it is to act in a timely manner. And the in regard to the DV 2021 applicants, the response rate was extremely low in terms of the overall amount of applicants who were notified versus the amount of applicants who actually submitted the information in a timely manner to be considered for appointment scheduling.
Right, and you mean those applicants that were selected, right?
Those that were selected for the DV 2021 program, the response rate was, I would say, extremely low for whatever reason. And again, those rank cutoffs, we've already announced the November rank cutoffs. We do so for the diversity visas a little bit at a faster pace in terms of making the determination. So again, people need to respond quickly to potentially be processed.
All right. Next question is, why not do Zoom interviews when it seems to work for local, district, and judicial proceedings in the United States?
I cannot comment directly on that, other than I believe we are legally mandated to do a personal interview. But again, that is a legal question which I'm not qualified to answer.
We do have a current legal mandate to do in-person interviews. So that is something that we are not able to do. We cannot do Zoom interviews at this point in time. All right, next question. When will the Mumbai consulate start processing immigrant visa interviews for the F2A category? This is a post-specific question. Again, Charlie, if you don't mind, I'll say, we need you to go to the U.S. Embassy or consulate website, the U.S. Mission to India website, and on that page will be the most up-to-date information on services that the specific embassy or consulate can provide at this time. All right. Next question. We appreciate your work, Charlie. Do you think that the EB3 India final action date could reach March 2014 in fiscal year 2022?
I would not expect that, and you should be pleasantly surprised if it does. As I stated in item F of the visa bulletin, you will find the visa availability projections for the coming months meaning through January. We will try to publish this type of information maybe again in the January visa bulletin, if possible, if the available information at the time makes it possible to do so. Again, I would only rely on this information that is published in this visa bulletin, or what you hear discussed in this event for making any determinations. I know there's a lot of blogs out there that talk and speculate, but again, they do not have all of the required information to do so. They do their best, but again, they don't have all the required information. And as with that, I've had to do with the change in my projection for the retrogression issue with India third preference. Last month, based on the information I had, I did not believe there would be a need to have any retrogression of the India third preference. Subsequent information, which is always changing, has made it necessary to potentially retrogress that date. So again, I would only rely on the information you're seeing in this visa bulletin. And if we see changes coming about, if suddenly something were to happen and we say, okay, the projection, we're now seeing a drop off of India demand or worldwide third preference demand or whatever, we always try to put information in the visa bulletin to give advance notice to everybody so that they can plan ahead, because we know this is extremely important for your future lives and all, and you need to do planning. So we try to provide information when it is available to get in advance so that you can plan for any issues such as this potential retrogression that has been already announced. so you can plan ahead.
All right, a couple more questions. A lot of Indian applicants are eligible for both EB2 and EB3. Can you provide estimates for demands considered together so that people don't need to jump lines unnecessarily?
I can't do so because I don't receive information in terms of the amount of applicants, say, that are downgrading or upgrading to a specific category. The reason being that information really wouldn't be too relevant to my decision making because I don't know how long it would take for such action to occur. So knowing that, for example, knowing that there's a lot of applicants downgrading to a third preference category, say downgrading to Philippine third preference, I wouldn't want to retrogress the Philippine third preference date on the assumption that those applicants are going to be downgraded in the near future. It would be better to wait because the approval of the downgrade may not occur. So I would not want to have taken an action which may have been otherwise unnecessary.
Right. There's a question that is about DB 2023. I'm just going to mention we can't predict what's going to happen with DB 2023. They're asking, will there be 80,000 visas for DB 2023? We cannot predict policy in the future. And if there are updates to the DB program, we will be posting them on our social media and on our website, our social media, travel.gov, and our website, travel.state.gov. So we cannot predict what's going to happen, and we will provide updates when they're available. Next question is, could you inform us when you expect any forward movement on the worldwide F4 final action date?
I would not expect, as in the bulletin says, do not expect any type of worldwide movement of the family dates through January. I actually believe there will be no movement for 6 months or more at this time.
We're going to take 2 more questions. First, why, for advancing the dates, did you not consider processing speed of USCIS, but for retrogressing, you are considering the processing speed of the consulates?
Well, I'm considering, I know the amount of demand that is pending at our consulates. For example, Mumbai, how many potential third preference cases that they have to process in the coming months if they were to resume final action on cases. So I have to consider that somewhat, but it is not a huge concern, but I do know that it would add to the demand that I already know that is out there for the USCIS offices. So Mumbai coming back online is only going to accentuate the quote problem with visa availability for India third preference applicants. In terms of moving the dates forward, I think you've answered your own question. If USCIS is not able to process, say, for example, employment cases at the rate you would expect or like, then moving the dates at a faster pace is not going to make any difference. It's kind of like, only a certain amount of water can go through a straw, depending how regardless of how much water you try to pour down it. So, and if we had moved the final action dates at a faster pace, although it would not have resulted in more number use at the time, it could have resulted in applicants, say, assembling documentation or doing things which then in the meantime, as there will be a retrogression or something, could, kind of negate their efforts in assembling documentation, and et cetera. And again, based on the fact that we are going to potentially have to retrogress the dates, it does show that the dates were advanced at a pace sufficient to utilize all available numbers if there had been the potential to do so. We cannot control the conditions in terms of staffing, et cetera, and the availability of officers either overseas or at USCIS offices to be able to process cases under these extremely trying COVID-19 conditions, which is an issue that has never been experienced before, and to some extent accentuates problems that may have already been in place because of staffing issues, et cetera. And I can say that even before this pandemic hit, that all of our consular offices abroad were already working at peak capacity. So, it wasn't like they had time on their hands to do, extra things. They were working at peak capacity, and you would have to contact the Immigration Service, but I have to assume that their offices were also working at peak capacity and to the best of everybody's ability.
Yes, definitely. All right, the last question for today is, what does it mean to be documentarily qualified for an EB downgrade? Is there a checklist? I'm assuming they're talking like how do you downgrade, perhaps?
That I'm not familiar with the exact downgrade process. The Immigration Service has certain required information for the downgrade, and once that is supplied and verified that the person meets the criteria, then either the downgrade or upgrade would occur. But that would be a question best sent to USCIS for them to respond to in terms of what they require in terms to be documentarily qualified. I can say that on the State Department side, if an applicant is notified to begin assembling certain documentation, they are provided with a specific list that you need to assemble and submit these required documents. And once those documents are submitted and verified, then the person would be considered to be documentarily complete.
All right. Thank you, Charlie. Thank you, everyone, for joining us today. That is going to conclude the live portion of this event. Reminder, you can find a lot of answers to many of these questions on our website, travel.state.gov. And you can follow us on Twitter, Facebook, and Instagram for information, including visa information for international travelers. And thanks again, Charlie, for all of your insight. And we will be back for the November Visa Bulletin next month.